Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On February 23rd, the court heard arguments in Arizona versus City and County of San Francisco, California, a case which concerned whether states with interest should be permitted to intervene to defend a rule when the United States ceases to defend. With the decision likely to be rendered in the coming weeks and months, I am joined today by the Honorable Elizabeth Murrill, Solicitor General in the Louisiana Attorney's General Office. I should note in advance that the Attorney General of Louisiana is listed in the brief for petitioners with the state of Arizona. Ms. Murrill, we're grateful to have you. Welcome.
Glad to be here.
So before we get to oral argument, could you please walk listeners through a bit of background, as we can note from the official question that there may be some prior history relevant for the court?
Yeah, so there's a 2019 rule that is at the center of this case that broadened the definition of public charge, which is a term in immigration law that is applied to people who are not eligible for a green card if the government thinks they're likely to rely too heavily on government aid. And so that rule was changed in the Trump administration, and it promptly was challenged in a number of different courts. The government defended the rule until the administration changed, and by that time, some litigation had ensued. Some of there were injunctions in the Ninth Circuit. There was an injunction that applied to just those states that had sued there. There was litigation in the Seventh Circuit in Illinois, and a nationwide injunction and vacature of the rule had occurred there. And so this was being actively litigated, and the administration decided to stop defending the rule and replace it with a new rule. There was a problem because the states wanted to intervene and continue defending the rule, and the federal government opposed the states' intervention in the litigation everywhere. So what the Supreme Court had already granted cert in the Ninth Circuit case, which the government decided to not continue defending. And so some states tried to intervene in the Ninth Circuit case, but they'd never been a part of that litigation. So the injunction didn't actually apply to those states, and it wasn't a nationwide injunction. That's what ended up being heard at the Supreme Court. But there was this significant underlying issue related to the Seventh Circuit litigation that permeated the discussion of at the argument.
Great. So having laid the foundation there, what in particular did the court focus on? Did anything surprise you here?
Well, initially, I think there was at the argument, all of the justices seemed pretty unsympathetic to the states in their intervention. I mean, they focused more on the APA avenue, that in enacting a new rule, that the states that had a concern could actually engage and bring a new lawsuit and challenge it in the DC Circuit and challenge everything that was going on. And as the argument continued, I think what was surprising is that several of them started to understand the argument was more of the government trying to insulate itself from any further challenge under the APA, and they started to see how the government was achieving that through rolling over in these cases, not actually engaging in an active repeal of the rule, and instead relying on acquiescence to injunctions and litigation. And so once they started to kind of zero in on that, the questions began to be more pointed to the Principal Deputy Brian Fletcher for the United States Solicitor General's office about their position on the state's intervention. And when Brian Fletcher acknowledged that the vacature in the Seventh Circuit was wrong, but that they were also opposing the states intervening in that case to correct that wrong. I felt like the tenor of the arguments and maybe a couple of justices kind of changed their position a little bit more and were more sympathetic to the state's desire to intervene and prevent collusive type litigation.
Do you have any sense on how the justices may rule? What do you expect the decision to turn on, if anything?
Well, Justice Kagan in the case seemed to agree with the states that the Biden administration was trying to circumvent notice and comment requirements that are imposed by the APA, and she felt like that was a reasonable position. It was, there was just a lot of disagreement about what the right solution was to this problem. She noted that the government had bought itself a lot of time when the rule was not in effect, that she felt like that was a problem, and that the court itself shouldn't, and I use her words, be green lighting that behavior for your administration or any other administration. But she questioned what the remedy should be. So I think that at the end of the day, my prediction is that there is, it's possible that the court as a whole that a majority of them will agree that states can certainly, I mean, I don't think there's any real disagreement that we could bring a new claim under the APA or that we can continue to litigate in the DC Circuit. I think because the government conceded that the vacature in the Seventh Circuit was wrong, we may see a majority of justices agree that there ought to be a basis for us to intervene in the Seventh Circuit, if not in this Ninth Circuit decision. One of the critical factors that I think came up, and I don't know whether they will actually zero in on this, I do think it will affect the outcome if they do, but is that there was a recognition well into the argument, into General Fletcher's discussion, that the Ninth Circuit case is not really over. I mean, they started at the beginning saying there's nothing for you to intervene in, but about 3/4 of the way through, there was a recognition that there actually is something for the states to intervene in because that case isn't over. It's only stayed. So the injunction there has not actually been vacated, and that then opened up this whole discussion about Munsingware and I feel like we coined a new phrase of Munsing wearing a case, using that term as a verb and not as a noun or as just title of a case. But Justice Kavanaugh was zeroing in on the need to kind of Munsingware the case, and that is to declare the entire case moot so that it would have no further effect and it would never be the basis for the repeal of a rule or the change of a rule, and that the government would actually have to not be proceeding on the basis of a moot case in order to repeal or change a rule. So I do think there will be some focus on Munsingware and the need and vacature and mootness. This is an issue that's permeating administrative litigation right now. It's scope of authority of a court when it vacates a rule, and whether that has nationwide effect or it only protects the states who litigated. I think the opinion will address all of those things in some way. I do think it will end up being a very narrow ruling, and it's possible that the states will lose in this case, but still see a path in other cases, because there is a concern about states not having the ability to actually defend or intervene at all.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.